Hello and welcome back to the Idaho Legal Aid Services web series about the eviction process in Idaho for non-payment of rent. This will be the final part, part 5, in which we're going to talk about what happens after the hearing. So let's talk about what might happen if you are able to win your hearing, or if the judge dismisses the case for the landlord not following the proper procedure. If you are in fact behind on your rent, you will still need to make an arrangement to get caught up. If the case was dismissed because the landlord did not follow the proper process, there's a possibility that the landlord could try again, but this time correct their mistake. And so fixing any sort of remaining issues is going to be important to keep you housed. Now, as far as what happens if you lose, it's important to note that the landlord is the plaintiff in this case, which means that it's their burden to prove their case. But if they win, the judge will order that possession of the property be returned to the landlord, so you won't be able to possess the property anymore, and that the lease will be forfeited. The judge may also order that you pay the landlord's costs and fees associated with the case. If you're evicted, if the judge issues an order of eviction, this would be a good point to try and work something out with the landlord as far as when you will be out of the property, have your possessions out of the property. Be reasonable. If they give you a week, that's probably a large amount of time, because if you're not able to reach an agreement with the landlord, then the judge will have to order when you will be out, and there's a possibility that you would have to be out that same day. That does happen sometimes, and so reaching a reasonable arrangement is going to be to your benefit if the judge has already ordered the eviction and that you need to move. As far as enforcing the eviction, once the court orders the eviction, they will also need to issue a writ of restitution to the sheriff. A writ is just a document that the court uses to tell the sheriff to do something. And in this case, it would be telling the sheriff to remove you and your property from the rental. You could be responsible for costs and fees associated with the landlord removing you and your possessions. And so again, I know this is a very tough situation to be in, but the more you can do to find agreement is going to be better for you in moving your stuff out, having time to do that, etc. This is also going to be a good moment to follow up again with community resources, contacting 211 by just dialing it on your phone, contacting Idaho Housing and Finance. These are places that might have information about emergency or temporary housing in your area. If you're unable to stay with family or friends, that's probably the next best step. You're going to need to look into possibly getting a storage unit for your personal items, leaving them at the rental, or not making a plan to remove them could lead to you losing your stuff, and we don't want that to happen either. Finally, if you have children and you've been evicted, often the school district where they attend school will have someone who coordinates services in these types of situations, and it would be beneficial to reach out to them. And if you have any other questions, if you want to talk to an attorney, if you have specific things about your situation, you can contact Idaho Legal Aid Services. Our website is idaholegalaid.org. And we also have a statewide intake number, so you can call this wherever you are, of 208-746-7541. All the best to you.